Today, we're going to be talking about my legislative priorities, but I want to be clear that the legislative priorities have been informed by the subject matter experts in my office who are sitting around the table today. One of my top priorities this year is to fight for crime victim service funding. Federal funding for crime victim services has decreased 90% since 2017. If our U.S. Congress fails to act, millions of federal dollars that crime victims rely upon will be cut, and the financial burden to address this gap will fall to our state lawmakers. Without continued and sustainable funding, there will be a dramatic reduction in services that help victims and survivors of crime. This includes community-based housing, crisis lines, civil legal aid, and trauma-informed care and counseling. We're asking lawmakers at all levels of government to act to make sure that crime victim services are a priority. Without essential funding, we will see life-saving services cut across King County and Washington State. In 2021, our state lawmakers enacted House Bill 1320, which overhauled our state's protection order statute. It increased access to justice. It modernized and aligned laws from multiple statutes into one consolidated chapter, and we also established a universal protection order petition. The implementation of House Bill 1320 has been very successful, but the process has revealed the need for some technical fixes to further improve our system. Senate Bill 5202 makes common sense fixes to Washington State's protection order statutes and enhances protections for survivors. Our state legislature has made vital improvements for survivors in need of court-ordered services, and this bill builds on that important work. This bill works to ensure that prosecutors have the information they need to notify survivors when their abuser has petitioned for the restoration of their firearm rights or when their abuser is ordered to relinquish firearms. It also ensures that abusers will face swift consequences if they are found with undetectable or unserialized firearms while prohibited. These are often referred to as ghost guns. This bill empowers survivors by providing a clear process to modify or terminate their ex parte orders if their circumstance changes. And this bill also allows newly adult children to seek renewal of protection orders by offering a trauma-informed pathway to continued protections.
Well, I think one thing that's different from when we first started doing this firearm work back in 2018 is just what Leesa highlighted, the increase of privately made firearms. So folks that are subject to court orders that are prohibited from possessing firearms but are bypassing the background check system, which is an incredibly dangerous public safety issue. And so this bill helps to address those gaps. And so we're focusing specifically on individuals that are in possession of ghost guns, so unserialized or even undetectable, so 3D printed firearms we're seeing more of as well, which is a big public safety concern. So it increases penalties for those individuals and helps us to be able to work on the enforcement part.
We have children, thousands of children across our state who are covered by protection orders, and if they age out of the order before this bill, they would need to re-petition for a protection order and re-prove domestic violence that's already been adjudicated. So giving them a pathway to renewal is really important. Among the other things, one is ensuring that the courts understand that entering mutual protection orders at the full order hearing is not a trauma-informed and it's not safe for survivors, and it really creates confusion for law enforcement on the scene. So we're really excited to see this bill go forward. So thank you so much.
This next bill, House Bill 1591, was designed to provide a more nuanced and trauma-informed sentencing option for the criminalized survivors of domestic violence, sexual assault, and human trafficking, where their criminal behavior was really influenced by their abuse. Defendants who are convicted of serious crimes like first-degree murder or sex crimes would not be eligible for relief under this bill. New York has had a similar bill for a long time, and other states, including Oklahoma, Louisiana, Oregon, and Minnesota, were considering similar reforms.
This is a new idea in Washington State of how do we respond to survivors who are being driven into the criminal justice system as a byproduct of their abuse. This is something that's very well known. The Department of Justice has studied So many have looked at the drivers of women's incarceration and survivors' incarceration nationally and internationally. And so having sentencing laws that actually reflect the state of the literature and understanding that is something that we're in support of. There's a lot of different ways to approach the issue, and this was a pretty big bill that a lot of people need to weigh in on. Unfortunately, there wasn't a work session that preceded the legislative session to be able to kind of work out some of the details, but I'm just really grateful that the legislature gave a hearing to it. My thanks to Representative Taylor and Representative Goodman and Representative Simmons, who've been working on kind of different aspects of this bill over time, and this brought everything together. The idea that someone's experience as a survivor of domestic violence, sexual assault, and human trafficking should be considered when they are being sentenced for a crime is, I think, just fundamental to fairness and something that this bill represents. It's going to be refined over time and worked on collectively across the state, but I'm just really excited to get a hearing.
We are also supporting Senate Bill 5067, which would serve to change the presumed impaired blood alcohol content level in our state from 0.08 to 0.05. Research shows that most drivers are impaired well before reaching the 0.08 level. There are more than 100 countries and some US states like Utah that have a presumed impairment level of 0.05. Moving our state's presumed impairment level to 0.05 will undoubtedly save lives in our state.
5067 will lower the per se limit to 0.05. This over 85% of the population of the world has BAC limits of 0.05 or below. The first 0.5 was in 1936, I believe, in Norway. It does not impact our robust hospitality industry. There is absolutely no research, nothing to show that it does. What it will do is it will inform people about impairment, and we see that across the board in places where the 0.5 goes into effect, that all BACs across the board go down, and we are giving you the crash risk assessment, which shows dramatic increases in crash risk at 0.5 and above. This bill will not cost the state any money. It will save lives. Undoubtedly, when we saw that, when we went from a 0.10 to a 0.08, and it will save billions of dollars across the state, because right now this state spends over $20 billion a year on traffic crashes. And if we see a decreased amount of traffic crashes, this state will save over $1 billion, and our county in King County will save over $600,000. One of the oppositions is that somehow hospitality servers will be greater affected, but that is absolutely not the case. And we saw that when we went from 0.1 to an 0.8. Hospitality servers are trained not to overserve, not to serve alcohol to people who obviously appear to be affected by alcohol. That does not change. That law will continue. We did not see an increase in litigation when we went from a 0.1 to an 0.8, but we heard the same pushback from the hospitality industry. All the countries that went from higher BAC per se's to an 0.5 have robust and drink more per capita than the United States. That includes France and Italy and Ireland and Australia. There are over 100 countries that have BACs of 0.05 and below. All the science shows that your driving abilities decrease at an 0.5. It is misleading to the people in our state that they can drive to an 0.8. People call it a legal limit. It is not. It takes about 4 drinks for the average male to even reach an 0.5. So it's not a beer on the way home or a couple drinks with dinner. So what it ends up doing is it helps teach everybody that drinking and driving impaired is dangerous, and that people end up self-regulating. And that's why across the board, you see even people who will drive with higher BACs now will drive with lower BACs. So across the board, you see all those BACs come out. You don't have to just look at Utah, but I will tell you that the 14 months before the pandemic kicked in, Utah saw a dramatic decrease in its traffic crashes and fatalities. Now, everybody saw increase with the pandemic, but they are now starting to see another decrease. So it is, there is no evidence, zero, that the hospitality industry is relying on to say that this will affect our beer, wine, and distilled liquor industry. None. And there is no evidence that shows that this will increase dram shop actions or civil litigation against servers. Zero, none. They have no evidence, but this is what they rely on. All the evidence across the nation, across the world, is that this will save lives and save money. Vitally important.
Under our current state law, a person is guilty of a hate crime if the person maliciously and intentionally commits a list of prohibited acts because of their perception of someone's identity. This "because of" language has been confusing to our jurors. Jurors often wonder if the defendant's behavior has to be motivated solely because of their impression of someone's identity. Senate Bill 53-8 simply adds the words "in whole or in part" in front of "because of." This makes it clear that the defendant's bias does not need to be the sole motive in order to be held accountable for hateful and criminal behavior. Currently, commercial sexual exploitation is a misdemeanor crime, and it is referred to as patronizing a prostitute under our current laws. House Bill 1265 would make this crime a Class C felony to more appropriately hold buyers accountable for their harmful behavior. This bill would also double the mandatory fines for convicted buyers and would change the name of this crime to commercial sexual exploitation, which is more modern and less harmful language.
This bill, while it is no longer alive, it was originally introduced through the House, and it really looks to serve as a protection for survivors of human trafficking. I would say that I have the privilege and the ability in this role as a prosecutor in this work to really see behind closed doors what the day-to-day public may or may not see. And the cases that do come across my desk are not only cases, but they are individuals' lives who have been severely impacted by being sexually exploited. And we know through data that individuals who are exploited are typically exploited at a very young age, and the vulnerabilities that these women and young men face are disproportionately among our marginalized communities. And we also know that the sex buyers are also most commonly privileged individuals with identifying as white males. This bill, as I stated, is no longer alive, but the fight to protect survivors and victims who have been trafficked and the voices of those who supported this bill are still being heard. And we're still going to push forward and continue to do the work to protect women and young men who are trafficked and sexually exploited.
We in the King County Prosecuting Attorney's Office have a long history of supporting changes to our law that prevent and protect us against gun violence. We are currently working with lawmakers to address illegally modified handguns, which are an immediate danger to the people of King County. When handguns are modified with switches or auto sears, they can shoot as many rounds as a machine gun. But under our current laws, modified handguns are still considered simple handguns, even though the impact of a modified handgun is far deadlier. In 2024, there were 107 individuals in King County who were killed by guns. Another 369 were wounded, and there were a total of 1,701 shots fired reported in all parts of King County. We are asking our lawmakers to change the definition of machine gun in Washington to match the long existing federal definition of machine gun. We also propose to increase the penalty for unlawful possession of a machine gun from a Class C to a Class B felony. Other states like Texas, Illinois, Oregon, and New York have increased penalties for the unlawful possession of a machine gun, and Washington should do the same.
The amount of rounds that are being found, right, at crime scenes is really alarming. And so it's a common sense, right? We want to be able to hold something that's so incredibly dangerous. We want to be able to increase those kind of clues, make sure that it's being reflected as how serious this issue really is. And so I would think it's similar to what this is like other states have done here. It's being more cheap.
How simple is it to get a switch for your handgun?
Well, I think many of us went to the training with the ATF that we were privileged to attend, and it's amazing they can 3D print that, right?
What are you typing in that?
So,
Just start it.
or they import it from somewhere else and really they're installing it. So it's really critically important that the legislature for this sort of still speak of.
So this is a bill that I have talked about quite a bit. We are working with lawmakers to address juvenile gun violence. Under our current law, it takes 5 convictions before a juvenile caught unlawfully possessing a firearm is eligible for serious interventions at our state juvenile rehabilitation facility. Every time a teen picks up a gun illegally, it is a potentially deadly situation, not just to them, but to our community.
Oh.
This is a common sense gun law. This is a common sense bill that can address young people who are caught carrying a firearm earlier. Young people who are caught carrying firearms are often in free fall and they are in need of interventions. We need to address the underlying cause of why they are carrying firearms. And if we could offer effective interventions earlier in time, we could prevent crime, we could prevent homicides, we could prevent gun violence in our community.
And we have roughly seven young people right now who were convicted of unlawful possession of a firearm and then went on to commit more serious crime. And so about 7 young people today are facing adult charges for either murder or assault in the first degree, and previously had an unlawful possession of a firearm conviction. But because of this gap, which has really existed for many years now in state law, there's no ability to meaningfully intervene before these young people end up escalating their behavior or themselves end up killed. So unfortunately, this is a bill that got referred to committee this year, but didn't get a hearing. So in your question of kind of like, why do bills die? This one died because the committee chair decided not to set it for a hearing. So hopefully through more conversation with legislators, we can advance it further next year.
This is a law and a sentencing scheme that we have tried to address on more than one occasion. I know that my predecessor, Dan Satterberg, also attempted this, and I believe prosecuting attorney Norm Mailing also tried to change this bill. So the King County Prosecuting Attorney's Office is supporting efforts to update our endangerment statute. Currently, if a child overdoses on fentanyl but does not die, the adult who caused the overdose can only be charged with a misdemeanor, not a felony crime. This is simply an outdated statute. This statute does allow for the felony prosecution of those who supply meth or have access to meth by children. This bill would simply update our statute to reflect what we are seeing in our community. When this statute was adopted and brought to life, no one foresaw the crisis that fentanyl would bring to our community. We are also working with lawmakers to support expanding substance use treatment options for parents so that we can address the underlying addiction that causes harm to their children and to our community. So this next bill would allow prosecutors, law enforcement, and firefighters to hire people who are legally authorized to work in the United States, but who are not U.S. citizens. Allowing prosecutors, law enforcement, and firefighters to hire those who are lawfully allowed to work in the United States would open a new pool of qualified applicants at a time where police, prosecutors, firefighters are struggling to recruit and hire qualified talent. This bill also empowers prosecuting attorneys' offices to better represent their communities. Currently, there are Washington State Bar qualified attorneys who are able to practice in private practice, but are not authorized to work in prosecuting attorneys' offices because you have to be a U.S. citizen. This next bill really serves to increase the funding that allows us to prosecute and investigate mortgage fraud cases. Currently, the state's mortgage lending fraud prosecution account is funded by a $1 fee every time a deed of trust is recorded in Washington state. At the time that this law was enacted 20 years ago, that $1 surcharge allowed us to have 2 deputy prosecuting attorneys and a full-time investigator. This fee has not been updated in more than 2 decades, and the same amount of money now funds only a half-time investigator and less than a half-time prosecutor in our office. Adjusting this surcharge to $5 not only reflects inflation, but it also allows us to continue to investigate and crack down on this insidious crime.
These cases involve really sophisticated schemes by criminal actors, and so they require a lot of law enforcement and prosecutorial resources to investigate, to charge, and then to prosecute in court. So without this funding, it is difficult for us to assist law enforcement and to maintain the resources ourselves to keep up with these schemes. Now, by way of example, in terms of the increase we're seeing, historically, when I first started doing this work 10 years ago, most of the cases we filed had loss amounts in the 5 figures. But starting a few years ago and really accelerating with the pandemic, where a lot of business transactions are now becoming virtual and done without face-to-face meetings, we're seeing schemes such as criminals selling homes out from underneath the actual homeowners to unsuspecting buyers. And we have the homeowner who's a victim, the lender who's a victim, the buyer who's a victim who thinks they bought a house free and clear and then find out they in fact paid off a criminal who didn't own the house, who posed as the real homeowner. And so the loss amounts we're seeing now are in the 6 figures and even the 7 figures as these scammers begin to use digital tools and virtual closings to really exploit the vulnerabilities in our system. So this funding will allow us to keep on top of these scams and to keep up with the increasing sophistication that these actors are using.
One thing I think it's worth noting is that this fund, the Mortgage Lending Fraud Prosecution Account, is something that everyone has thought was a good idea for a long time. It was created in 2003. It's been renewed 3 or 4 times since, oftentimes with unanimous support or near unanimous support. The issue is just that $1 fee has never been adjusted upwards. So it hasn't kept track with inflation. It also hasn't kept track with changes in how the real estate market tends to work, because it is collected when a deed of trust is recorded, which means when a property is sold with a mortgage. With the rise in cash sales and other forms of transactions, that fee is not collected. So it's not just a matter of inflation, it's also a matter of changes in the market. I think it's really important to note that this is a fee that's collected on large dollar value transactions. And so in that context, a fee of $5 to the individual seller and buyer is pretty much imperceptible. In the aggregation, however, this is money that makes a significant amount of difference. And that's why we are proposing that the prosecutors continue to have the tools to go after this really insidious and rising problem.
Mortgage fraud encompasses actually a broader range of activities than you would initially assume. Principally and historically, it encompasses the type of activity that we saw leading up to the crash in 2008, meaning mortgage fraud on the lender side, where lenders are cutting corners, inputting false data for their borrowers to issue the loans and get their commissions and really get loans out that really shouldn't be going out, thus putting our whole economic system at risk with all these homes that really shouldn't be financed. But as As time has passed, of course, criminals go where the money is. And so when the economy went down after '08 and a lot of people were left underwater, the criminals shifted from on the origination side of the loans to targeting vulnerable homeowners who were now underwater on their loans and seeking relief to get out of their mortgages. So criminals now started targeting homeowners with promises of getting them out of their loans or getting loan reductions, and really just scamming money away from borrowers that they really weren't able to manage their payments, and they thought they were getting relief, but in fact they were just paying scammers. As time has developed, we've seen it encompass other things. Now, like I said, we're seeing home sales where the sellers are actually criminals posing as the buyers. We're seeing forgeries pop up a lot more often, where people file false documents with the recorder's office, pretending to either own debt, own loans, or own homes, and then use that to seek money from unsuspecting buyers, borrowers, sellers, lenders. So it really does protect, it protects low-income people facing foreclosure, and it protects wealthy commercial investors who are trying to buy properties and need to be assured that what they're buying is actually a legitimate transaction.
We in the King County Prosecuting Attorney's Office are working with lawmakers to fix our state statute and to tamp down on sex abuse, child sex abuse. Currently, we cannot charge defendants for creating images of child sex abuse unless the child victim is conscious or knows that they are being recorded. This simply doesn't make sense. Under the current laws of our state, prosecutors cannot charge defendants for possessing sexually explicit AI-generated images of non-identifiable minors. This, again, makes no sense. We are working to change that. We are working to hold child predators accountable for their disturbing and harmful behavior. There is also a current 3-year statute of limitations under our state law for prosecuting child sex abuse image cases. Even though these images have the potential to live forever on the internet, which can re-traumatize victims for decades, we want to see the statute of limitations for these crimes extended to 10 years. People who peddle in the misery of sexually abused children must be held accountable.
Thanks for being here today.
Thank you so much. And thank you to all of our subject matter experts. Thank you for your good work every single day.